Federal agents.
I work here. That badge is court issued. I'm a certified federal interpreter assigned to this floor.
We know exactly who you are.
Not outside. Not on the street. Inside, badge around her neck, sandwich in hand, steps from the courtroom where she spent every working day making sure people who couldn't speak English could still understand their rights. She showed them her court-issued ID. She told them her DACA renewal was pending, stuck in a processing backlog, same as thousands of others. She asked them to check the system. They put the cuffs on anyway. Within minutes, the judge halted every proceeding on the floor. Hearings canceled. Families who had traveled hours for their court dates turned away. Interpreters don't just translate words. They hold entire cases together. And the agents who walked into that hallway had no idea what they had just pulled out. But here is what they really didn't know. Sarah Johnson had been in that courthouse for a reason that had nothing to do with translation. She had been watching, documenting, and waiting for exactly this moment. This is the full story. If you are ready to see institutional racism taken down, like this video and drop a comment telling me where you're watching from. And if this is your first time here, hit that subscribe button right now because you won't want to miss tomorrow's story of cops messing with the wrong people and finding out. Let's continue. They came at 12:17 inches the afternoon. 3 agents, plainclothed but unmistakable, the practiced stillness in their shoulders, the IDs clipped to their belts at the precise angle that communicated authority without announcing it. They moved through the third-floor hallway of the federal courthouse with the coordinated calm of men who had done this before, in places far less formal than this, and who saw no reason why this should be any different. Sarah Johnson was standing near the vending alcove, her back half turned to the main corridor, a half-eaten turkey sandwich in one hand and her phone in the other. Her court badge, laminated, photo-bearing, issued by the Office of Court Administration, swayed from the lanyard around her neck. She was reading a message from her attorney. The renewal paperwork had cleared one more internal hurdle. The update was cautiously optimistic. She did not hear them until they were already close. The first agent stepped into her peripheral vision and said her name, not a question. The second moved to her left. The third positioned himself between her and the elevator bank at the end of the hall. It took fewer than 4 seconds. The sandwich fell. She did not drop it, her hand simply forgot it was there. The handcuffs clicked into place with a sound that seemed, to Sarah, disproportionately loud, a sound that the entire hallway heard, that stopped the 2 clerks emerging from the copy room mid-step, that made a young paralegal in a green blazer press herself against the wall as though hoping to disappear into it. The metal was cold and calibrated. The agents moved efficiently, without roughness, which somehow made it worse, as though what was happening to her required no more care or consideration than routine. She lifted the badge with her free hand before the second cuff went on. She held it toward the nearest agent at eye level. Her arm extended with a steadiness that came not from calm but from something older and quieter than calm, the practiced composure of a woman who had spent years making herself legible to people who did not want to see her. The agent glanced at the badge the way a person glances at a receipt they already know they're going to discard. He looked away. In the months that followed, that glance, its brevity, its total absence of hesitation, would appear in her written account filed with the DOJ's Office of Professional Responsibility. It would appear again in the civil rights brief, and again in the congressional testimony. But in the moment, in the hallway, it was simply what it was: dismissal, compressed into a fraction of a second. Around her, the courthouse rearranged itself in response to her absence. Word moved fast inside federal buildings, faster than policy, faster than procedure, and far faster than the agents anticipated. Within 6 minutes of the arrest, a clerk supervisor had reached the courtroom and placed a folded note on the bench. The judge read it mid-sentence, paused, and set down her pen. 3 cases were continued. 2 hearings were canceled outright. A family from Guatemala who had traveled 4 hours by bus for a status conference sat in the gallery for another 40 minutes before someone with enough Spanish to apologize found them. Sarah Johnson was the only federally certified Spanish court interpreter assigned to that floor that day. She had been, in one form or another, the only one for the better part of 3 years. This was not a coincidence of scheduling. It was the predictable result of an institution that had leaned on her fluency, her availability, her professionalism, and her willingness to absorb twice the workload at 2/3 the professional recognition, and had never, in 3 years, moved to address its structural dependency on a single contractor with a pending immigration status. She had known this. She had filed 2 internal memos about interpreter coverage gaps. Both had been acknowledged. Neither had produced action. The colleagues who watched her being escorted toward the elevator knew some version of this, too, in the ambient, unspoken way that institutions hold collective knowledge about their own contradictions. Several of them had worked beside her for years. Some had borrowed her desk lamp, her phone charger, her translation notes when their own cases ran long. A few had said, in the break room, in lowered voices, that it was impressive how far she had come, phrasing it, always as a compliment, never quite examining what the sentiment implied about where they assumed she had started. None of them spoke. The elevator doors opened, the agents guided her inside. One held the door with his forearm as the other confirmed their route into a radio clipped to his lapel. Sarah kept her eyes level. Her attorney's unread message was still on her phone screen, face down on the hallway floor beside the sandwich. The doors closed. 12 minutes later, she was standing in an open courtroom. The arraignment judge, the Honorable Patricia Osei, had been informed of the arrest through channels that moved only slightly more slowly than the rumor. She had cleared her afternoon calendar with 2 phone calls. When the agents brought Sarah through the side entrance, still cuffed, the judge observed her from the bench with an expression that gave nothing away and recorded everything. Sarah stood straight. She had not been crying. Her lanyard, badgeless now, the badge had been collected as part of the detainment protocol, hung against her chest like a stripped credential, which is exactly what it was. She told the court, in measured, unbroken sentences, what she did for a living. She explained the renewal timeline in the specific procedural language of someone who had read every line of every filing, because she had. She named the date her DACA application was submitted. She named the date the agency received it. She named the 90-day processing gap that placed her in the technical limbo the agents had cited as authority for the arrest. The lead agent, when addressed by the court, confirmed the DACA lapse with the confidence of someone citing code rather than exercising judgment. The courthouse was a public facility. The hallway was an accessible common area. Federal enforcement authority did not require judicial consent in common areas. These statements were accurate, and they were accurate in exactly the way that a scalpel is accurate, precisely shaped to cut without addressing whether the cut was right. Judge Osei looked at the agents for a long moment. Then she looked at Sarah. She began to speak about the role of the judiciary in the constitutional order. She spoke about the concept of courthouse sanctuary, which was not law but was tradition, and about what the erosion of tradition tends to precede. She used the phrase assault on judicial independence with the particular quietness of a person who means every word and does not need volume to prove it. Sarah listened. Her hands, still cuffed in front of her, rested at her waist. Her breathing was even. Her face was composed in the way that faces are composed when the person wearing them is doing several things at once, processing the moment, measuring what could still be saved, and holding very still the knowledge of something that no one else in the room yet knew. Outside, in the hallway, her phone had been picked up by a clerk who recognized it. The screen had gone dark. On the secure server she maintained through an encrypted DOJ-linked account, a scheduled upload was running silently, automatically, on a timer she had set 48 hours before. The judge was still speaking. Sarah kept her eyes on the bench. She did not look toward the door. She did not look at the agents. She waited. The gavel came down once. Not in the theatrical way of courtroom dramas, no raised arm, no performative warning. Judge Patricia Osei brought it down with a single, deliberate strike that landed in the silence like a period at the end of a sentence everyone had been afraid to finish. The sound did not echo. It absorbed. The murmuring stopped. The agents, who had been radioing in quiet intervals since Sarah arrived, went still. She let the quiet sit for 3 full seconds before she spoke again. What followed was not a speech. It was a ruling, methodical, citation-laden, and delivered with the controlled precision of someone who had anticipated this moment as a theoretical possibility and had prepared for it accordingly. She named the relevant Federal Circuit decisions on courthouse access restrictions. She cited the Judicial Conference's 2018 policy guidance on courthouse enforcement actions. She referenced 2 district court orders from the prior decade in which ICE arrests made within federal building corridors had been challenged and partially invalidated on grounds of judicial process interference. She was not improvising. She had done this work before, or someone in her chambers had done it and left it accessible, which amounted to the same thing in a courtroom. The lead agent shifted his weight. His partner had stopped writing on the notepad he'd been holding since Sarah entered the room. Across the gallery, 2 assistant district attorneys leaned together and exchanged something low and inaudible. The court reporter's fingers, which had paused during the gavel strike, resumed their motion. The judge's conclusion was direct. Sarah Johnson's pending DACA renewal, filed within the statutory window and confirmed as received by USCIS, constituted a rebuttable presumption of lawful status during the processing period. The arrest, conducted without a judicial warrant inside a federal courthouse during active judicial proceedings, represented at minimum a procedural violation subject to immediate review. She ordered Sarah uncuffed. She ordered the agents off the premises pending that review. She stated, with the flatness of someone not particularly interested in argument, that any future enforcement action targeting court staff or contractors inside the building would be treated as contempt. The agents did not leave immediately, they made phone calls. They conferred at the back of the room in low voices, one of them holding his radio against his chest so the transmission wouldn't carry. The judge did not watch them. She was already reviewing the next document on her bench. A clerk, the same one who had delivered the note that started all of this, approached Sarah with a small key. Sarah extended her wrists without ceremony. The cuffs came off. The clerk set them on the edge of the defendant's table and stepped back quickly, as though the metal were still warm. Sarah rubbed her left wrist with her right thumb. It was a small, involuntary motion, the kind the body makes when the mind is elsewhere. And her mind was elsewhere. It was running a precise internal inventory, which agent had spoken over her badge, at what timestamp, facing which security camera. Which of the two had dismissed her renewal status without verifying it in the system, a violation of the agency's own field protocol, Section 8.4, which required electronic confirmation before a detainment could be classified as lawful removal enforcement rather than investigative stop. She had memorized Section 8.4 11 months ago. Around her, the room had reorganized itself emotionally. The colleagues who had watched her escorted through the hallway in silence were here now, some of them. A paralegal she had trained 3 years ago on Spanish medical terminology sat in the second row with her arms crossed and her jaw set in a way that looked like it might be solidarity, or might be the residue of shock. 2 clerks near the door had stopped pretending to look at their phones. The court reporter had swiveled slightly in her chair. None of them spoke to Sarah. But they were watching her now in a way they had not watched her in 3 years of working beside her, with attention. With something approaching recognition, as though a familiar piece of furniture had suddenly revealed itself to be structural. She understood this. She had no particular bitterness about it. Institutions move toward people when those people become useful to the institution's self-image. It was mechanics, not morality. What mattered was the position it created. The agents, after a third phone call, began to move toward the exit. The lead agent paused at the door and turned back. He did not look at the judge. He looked at Sarah, the kind of look that is meant to communicate that this is not finished, that the authority he carried out of the room would reconstitute itself in another room, at another time. Sarah held his gaze for exactly as long as it took him to look away first. Then she checked her watch. The gesture was small. Nobody in the room would have registered it as significant. But it was, in the same way that the position of a second hand on a clock face is not decorative, it is information. The upload she had scheduled had been running for 31 minutes. At the file size she had calculated, accounting for the building's documented Wi-Fi throughput, the transfer would complete in approximately 4 more minutes. She allowed herself, very briefly, a faint adjustment at the corner of her mouth, not a smile in any legible sense. Settling the particular expression of a person who has been holding a very specific kind of patience for a very long time and can now feel it beginning to resolve. In moments like this one, when an institution's machinery is exposed and an overlooked person stands at its center with more information than anyone else in the room, the question worth sitting with is not whether justice prevailed today. It is whether what just happened is a win, or simply the first move in something much longer. Type yes in the comments if you believe fighting back inside the system is worth it, or tell us why you think systemic change requires something deeper. Like and share this story if it should be heard. The judge signed the order releasing Sarah into the custody of no one. Just released. Into the courthouse hallway. Into the same air the agents had just vacated. The courtroom exhaled. Sarah picked up her lanyard from the clerk's table, looped it back around her neck, and stood very straight. The badge was still missing, collected, tagged, placed in an evidence envelope somewhere in a federal vehicle that was currently pulling out of the parking structure. She would need to have it reissued. She added it to the list. She was not done. She had barely started. Chapter 3, The Underdog's Revelation. She spoke before the room had fully settled. The gallery was still processing, some people reaching for coats, some replaying the last 20 minutes in their heads with the slightly dazed expression of people who had expected a procedural footnote and gotten something else entirely. The judge had begun reviewing the afternoon's rescheduling options with her clerk. The 2 assistant district attorneys were already in the aisle. Sarah said, in a voice calibrated for the room's acoustics and nothing more, that there were things the court needed to know before this matter was closed. The room stopped. It was the voice that did it, not raised, not strained, not the voice of someone asking for attention. It was the voice of someone who had decided that now was the time and had structured their sentence accordingly. Judge Osei looked up from her clerk's notepad. The district attorneys paused mid-step. The court reporter, who had technically been off the record, put her hands back on the keys. Sarah reached into the interior pocket of her blazer and produced a folded document, a single sheet, government letterhead, a specific shade of off-white that anyone who worked regularly with DOJ correspondence would have recognized immediately. She set it on the defendant's table and smoothed it flat with one hand. The letterhead read, United States Department of Justice, Office of Professional Responsibility, Internal Enforcement Integrity Unit. She had been embedded in this courthouse for 14 months. The assignment originated from a pattern of conduct investigation that the OPR had opened 18 months prior, following a cluster of complaints from immigration attorneys across 3 federal districts, complaints documenting a consistent set of behaviors, warrantless courthouse detentions, coercive field interviews conducted without proper advisories, and a systematic disregard for the procedural protections that field agents were required by internal policy to observe. The complaints were credible, they were specific, and they were numerous enough to constitute a pattern. What the investigation lacked was documentation from inside an active courthouse environment, gathered by someone with the access, the training, and the cover to collect it, without disrupting the conduct being observed. Sarah Johnson had the access. She had the training, a certification in federal investigative procedure that she had completed 2 years before taking the interpreter role, and which appeared nowhere on the resume she had submitted to the court. And the cover had been constructed carefully, a genuine DACA status, a genuine interpreter certification, a genuine professional history, all of it real, all of it earned, with one deliberate modification. The renewal filing had been timed, not delayed by bureaucracy, positioned, with the OPR's knowledge and assigned authorization from the Deputy Attorney General's office, to create precisely the kind of enforcement window that had been documented in the original complaints. The lapse was the bait. The body camera was a modified device embedded in the ID badge lanyard clip, the same lanyard the lead agent had noted and dismissed within the first 15 seconds of the arrest. It had captured everything, the moment they identified themselves, the dismissal of her badge, the cuffing procedure, the exact words spoken in the hallway and the elevator. The audio logs were separate, recorded through a secondary device that had remained on her person throughout the proceeding. Both streams had been uploading continuously since 12:19 p.m., to a server maintained by the OPR's technical division. The upload had completed at 12:52. The courtroom absorbed this in stages. The lead agent, who had returned to the building lobby after his superior instructed him to wait for further orders, was informed by radio. The court officer near the door watched his face through the narrow window in the door panel and later described it, in her statement, as the expression of someone doing rapid arithmetic on a problem they had not known they were in. The judge set down her pen. She read the authorization document twice. She asked 2 procedural questions about chain of custody for the recordings, and about the scope of the OPR's disclosure authority in open court, both of which Sarah answered with the specificity of someone who had rehearsed the answers because she had written part of the protocol they were drawn from. The judge nodded once, slowly, the way experienced jurists nod when they are confirming that a thing is exactly as unusual as it appears to be. The colleagues in the gallery underwent a different kind of reckoning. The paralegal in the second row uncrossed her arms. The clerk near the door stopped leaning against the wall and stood upright. The assistant district attorneys, still in the aisle, looked at Sarah with an expression that was not quite awe and not quite embarrassment, and lived in the specific register of both the expression of people recalibrating, rapidly and not altogether comfortably, what they had assumed about the person they had been working beside for over a year. Sarah did not perform the moment. She had not built toward it for 14 months so that she could inhabit it as spectacle. She answered the court's questions. She provided the OPR contact information for follow-up. She noted, for the record, the 2 specific protocol sections the agents had violated and the timestamps at which each violation occurred. She spoke the way she had always spoken in that building, clearly, accurately, and without requiring the room's belief as a condition of the truth. The agents formally withdrew under orders that came through 40 minutes after the courtroom disclosure. The judge issued a standing order restricting enforcement actions within the building pending the OPR review. The clerk reissued Sarah's badge from a spare template while the original remained in evidence. Sarah walked out of the courthouse at 3:44 inches the afternoon. The light was lower than it had been at 12:17. The same parking structure stood across the street. The same food truck that had been there at lunch was beginning to close down for the day. The city continued at its ordinary pace, indifferent to what had just occurred inside the building behind her, as cities tend to be. She did not look back at the building. She had spent 14 months inside it and knew every square foot. What she needed to know about it was already documented, time-stamped, and in the custody of a federal server. She had come in overlooked. She had been cuffed in a hallway by people who saw a badge and decided it didn't count. She had stood in a courtroom still wearing the marks of handcuffs on her wrists and spoken in the measured, procedural voice of someone who had always known this day was coming, who had, in fact, built toward it with the patience of a person who understood that truth does not require an audience to remain true. It only requires someone willing to carry it long enough. She put on her sunglasses, turned east on the sidewalk, and walked.
If you like this video, make sure to hit that like button, subscribe, and turn on the notification bell so you don't miss the next story. Share this video with someone who would appreciate it, and let's keep building this community together. And before you go, drop a comment below. I'd love to hear your thoughts on what stood out to you the most. Until next time, stay safe, stay curious, and I'll see you in the next.